Because if something proves out in the Utah regulatory sandbox and is demonstrated by data to be valuable and useful and safe for customers and consumers, well, then the open question becomes, why can't that be allowed elsewhere?
Today on Law Next, we're going to take an in-depth look at an unprecedented experiment in Utah to reimagine the way legal services are regulated and delivered. My guests today are Utah Supreme Court Justice Dino Himonas and John Lund, past president of the Utah State Bar and a partner with Parsons, Bailey, and Latimer in Salt Lake City. They were the co-chairs of a working group that in late August issued a report that called for the state to profoundly reimagine the way legal services are regulated. 2 days after the group issued its report, the Utah Supreme Court ordered implementation of the pilot program the report outlined, including a so-called regulatory sandbox that will allow a limited market of non-traditional legal services providers to operate in the state. This is Bob Ambrogi, and you're listening to Law Next, the podcast that features the innovators and entrepreneurs who are driving what's next in law. We'll get to today's interview in just a moment, but first, let's hear from the sponsors who generously support Law Next. And now, on to this week's interview. Justice Dino Himonas, welcome to Law Next.
Oh, thanks for having me.
And John Lund, welcome to you.
It's a pleasure. Thanks.
Justice Himonas, let me begin with you. You and John chaired this working group, which the Supreme Court had appointed originally, and in August you issued your report. The report was titled Narrowing the Access to Justice Gap by Reimagining Regulation. Justice, what was the genesis of this? Why did the court form this working group in the first place, and what was its mission?
Let me start, let me go back about 4 or 5 years. And that is when the court really recognized that the access to justice gap was something that needed to be seriously addressed. And we started implementing a variety of programs, the licensed paralegal practitioner program, online dispute resolution, and started attending some conferences. John and I had the privilege of attending a conference up in the Northwest about 2 years ago, where we heard Jillian Hadfield speak about regulatory reform. And I think we just kind of immediately saw its potential. John went back and I think convinced the bar that this was something that needed to be seriously studied as part of the access to justice movement. And this specific project started when the bar wrote us and asked us to form a task force to kind of evaluate it.
And so the bar wrote to you, wrote to the Supreme Court in August. John Lund, what were some of the concerns that the bar was seeking to address at that point?
The real driver for all of this is the problem with huge portions of our population unable to access or unwilling or uninterested in accessing legal services. And we're dealing with a delivery system for legal services and a pricing system for legal services, all of which really haven't stayed apace of the way the world works. And so we're in a place where lawyers are becoming increasingly irrelevant to people, even people who have legal problems. And that, part of that is framed in the context of the access to justice gap for sure, which the courts, realize as many increased numbers of people there on a pro se basis. So I think the drivers were really twofold. One is, and primarily, our bar serves the public as well as our members, and the public, it means all of those people who just simply aren't utilizing legal services at all and essentially trying to go it alone through various parts of their lives. But secondarily, I think to lead the profession forward into this area, if the legal profession is essentially relegated to only serving well-heeled folks and corporate concerns who can afford the hundreds of dollars per hour for services, we really have lost touch with the broader population we're trying to serve.
I mean, I have to assume this has an impact. This situation has an impact on the courts, Justice Simonis. I mean, the report that you've ultimately put out made the point that I think in 93% of all civil and family law disputes disposed of in the 3rd District in Utah had one party who was unrepresented by a lawyer at all. I mean, that must have an impact on the court system as well as the legal system more broadly.
Right. Sure. We know that for some time now, there's been an explosion in the number of unrepresented parties appearing before the court, and for a variety of reasons, as John mentioned, right? Not just, funding and the ability to pay, but whether it's worth hiring somebody at all. I think there was a recent study done by the National Center for State Courts that suggested that in 75% of all civil cases, the judgment was $5,200 or less. I mean, even if you could afford to hire counsel at that, it doesn't make economic sense. So, huge problem in terms of these folks accessing the system for whatever reason and just needing some help, right?
So the Supreme Court appointed this commission a year ago. You spent a year looking at this. How did you go about this? What were some of the issues you were looking at, and what was the process over the past year of preparing this report?
So John and I got together and decided on a membership. We were fortunate in that we convinced Jillian Hadfield, who's one of the leading thinkers in this space. Dr. Tom Clark is retired now from the National Center for State Courts, but was a vice president there. Margaret Hagan at Stanford, Lucy Rico had been at Stanford, and some local bar leaders as well. So John, the then current president, Dixon Burton, the head of the Futures Commission for the bar, general counsel, and some others as well from the courts and the community. We kind of just set out to brainstorm initially about how to tackle this, and after a few phone call meetings, we all got together, and it really kind of coalesced into 2 tracks. One at which we're looking at amending the rules that govern lawyers, principally 5.4, and the other is setting up an independent regulator that in a sandbox approach to testing kind of innovative approaches to providing legal services or practicing law, if you will.
And 5.4, of course, is the rule that prohibits or fee sharing or non-lawyer ownership in legal practices. Why did you think it was important to look at that rule?
So I understood that the limitation that's placed by 5.4, or the rules generally, and 5.4, I think in particular, has stifled innovation. And in this age of disruption, the ability to capture and take advantage of innovation to us seemed crucial. And we had some guidance in this area from the LSA, the Legal Services Act that was passed in 2007 in England. So we spotted it as a real roadblock and decided that something needed to be done about it. And we're not alone. I mean, I'm pleased to announce that last Friday, a week ago, Arizona released its report and is proposing the elimination of 5.4 and some other rules as well.
Right, and meanwhile, Oregon is somewhat following your lead in terms of licensing, looking to license paraprofessionals and moving forward on
as is Arizona. I think California is looking at what to do with 5.4. I understand Illinois, maybe other states. So this is a growing movement.
We'll get back to my interview in just a moment, but first, let's take a break to hear from the sponsors who generously support Law Next. And now, let's continue this week's interview. John, what about from the bar's perspective? I mean, this is, I have to imagine that there are a lot of lawyers in Utah, because I know there are a lot of lawyers elsewhere who are troubled by talk of these kinds of reforms and especially about this idea of allowing possible private investment in law practices. What's been the response in Utah?
Well, I would start by saying, first of all, that I believe our bar's leadership has generally been supportive and, in fact, involved in sort of trying to move this forward. You're right that there are people who get concerned about change, and the bottom line is we haven't had a huge hue and cry from the membership, but I think we certainly want to be sensitive to the concerns of practicing lawyers. At some level, we're talking primarily about expanding the market for legal services. We're talking about a much wider swath of the population thinking that this might be something they could actually get some legal service around. Now, that may not be in the traditional mode of calling up the solo practitioner that's down there on Main Street and going in for a consultation. It may be that it's instead utilizing an app that accesses the more specific legal need that they need or that they have, and the real role that the Main Street lawyer is playing is that he or she is behind the app, and the app is really the mechanism by which that person is finding the lawyer and being able to access the lawyer in a way that's efficient, that's affordable for the client, but also, it may be really carving away. There's a statistic about the number of hours of billable time that your typical solo practitioner gets every day, and I think it's under 3 hours of billable time. But why?
Right.
Because they're spending a lot of their time managing their office, dealing with their rent, marketing themselves, whatever they're doing, other than actually providing legal services to people. So, some of the concept here that we think really inures to the benefit of the practicing lawyer, is to let business acumen, let marketing skills, let venture capital funds that maybe come from other sources other than the lawyer's own or the law firm's own pocket be brought to bear. And in the end, it may be that the way in which the lawyer is delivering legal services is different from the traditional model of providing the service and then sending the bill out, and expecting payment in 30 days. But in the end, I think we expect this to really yield more opportunity for lawyers, not less.
So, in the report that you issued in August, in Justice Simonis, you alluded to this already. You made recommendations to essentially address this issue along two different tracks, and the one track, as you mentioned, is to loosen regulatory restrictions, not just with regard to ownership and investment, but also with regard to some of the other rules around lawyer advertising and solicitation and referrals. But you've also, in the second track, recommended a new approach, perhaps, I guess, to regulation of the delivery of legal services in the state. Can you explain what you've recommended here?
Sure. So it's a paradigm shift, right? These existing rules are prescriptive, and they're not really based on any data. What we're proposing is regulating based on data, on empirical experience, and at regulating entities. That's that's a kind of change. It's a profound change, and that we think will make a real dent in the access to justice gap. But as John and you alluded to, right, it scares people when you're talking about change at that level. But I think this, if you think about this logically, just it makes a ton of sense. And I think when people think about it and think about it with an open mind, they'll realize it.
So how do you go about that? I mean, what specifically? What is the report recommending? Well, more than recommending. At this point, the Supreme Court has now approved and approved a first phase of implementing these recommendations. So, what does that mean? What is going to happen going forward in Utah that isn't there now?
So we've it's under consideration. John and I are co-chairing a new group that's looking at exactly how to implement that, made up of some of the same individuals that were initially involved, and then some new people, some people that you're probably familiar with, Rebecca Sandifer, Justice Christine Durham. So some people that have a lot of experience in the access to justice space, and the particulars are still to come. I mean, we're in the early stages. We've held our first two meetings in deciding exactly how to go about implementing the phase one regulator. But the purpose behind the phase one regulator is really to kind of take our own advice and test these regulations, test the best way of implementing them, and then make a final recommendation to the court based on data about how best to go about achieving the goals of reducing the access to justice gap and kind of maintaining the advantages of innovation and technology.
This phase one regulator, John is what's the bar's involvement in this? I mean, essentially there will be two parallel regulatory structures, as I understand it. There's going to be the regulatory structure that regulates lawyers, as they always have been, and a parallel kind of a test, or I think you're alluding to it as a sandbox regulatory structure that will regulate entities, non-traditional entities delivering legal services. Is that correct?
Well, yes, basically. You asked about the bar's involvement. In addition to myself, we have our president-elect of the bar, Heather Farnsworth, is a member of the task force, and a couple of other people from our bar membership who are participating in the development of this. But you're right, Bob. There'll be a separate entity, separate from the bar, not controlled by the bar, which will be assessing these proposed services, trying to figure out how to collect data about them and the like. There's an overlap, about kind of where is that line? What is something that a lawyer can do because the rules are relaxed and the lawyer can simply take advantage of the relaxed rules, maybe around referrals, arrangements on a referral or something like that, versus when has something become sufficiently different from traditional provision of legal services that we would like for it to be something that the regulatory sandbox regulator is aware of at least and able to sort of follow and understand. To Justice Simonis's point about data, we need to know if the changes that we're making in the regulatory scheme for lawyers are making any difference, positive or negative. Are we exposing consumers to more harm somehow because lawyers, can do things differently, or because somebody other than a lawyer provides that service, or are we providing them more with some more benefit and some more value? So that's the study project for the next couple of years.
And is it fair to say that this regulatory sandbox, this other regulatory body, is focused on companies that are going to use, not necessarily companies, I guess, but alternative legal services providers that will use technology? I mean, is it fair? I guess what I'm trying to ask, not very artfully, is technology a core part of this? Is technology a core part of what you're looking at here? In other words, are you trying to bring in companies that are able to deliver legal services in different ways, using different methods? Is that kind of what you're getting at here?
Sorry.
No, go ahead.
I think it would be a mistake to think about it just in terms of technology. I mean, that's certainly something that we want to be able to capture and take advantage of. That's a big part of it. But I would not ignore the benefits that might come from non-technology driven innovations and our ability to test those as well.
Can you
Yeah,
give me an example of what those might look like? What are some of the? I mean, just in your, I realize it's early on. You're just getting started, but do you have thoughts about what some of these entities might look like, or what these alternatives might be?
well, I can offer one up.
Yeah.
There's a question about multidisciplinary services, right? If a customer, say a small business person, could come to the same shop and provide their information once to a lawyer and an accountant and a financial planner and whoever else might be appropriate to have on that team, and get the service from a sole source, would that be a better model than current arrangements where you go to four or five, three or four anyway, different professional providers to get your business supported?
So in the report that you issued, I'm going to just quote from that. It says, the regulatory sandbox is a policy structure that creates a controlled environment in which new consumer-centered innovations, which may be illegal or unethical under current regulations, can be piloted and evaluated. The goal is to allow the court and aspiring innovators to develop new offerings that could benefit the public, validate them with the public, and understand how current regulations might need to be selectively or permanently relaxed to permit these and other innovations. So, and I understand again that you're in the early stages of starting to put this together, but you're looking at a roughly 2 year first phase of this, as I understand it. How will companies? How do you expect to find the companies that might get involved in this, or the entities that might get involved in this? What will be the process for them becoming involved in this, as far as you know it at this point? John or
John, go ahead.
Well, we are taking the step right now of putting a website out that will be the website for our group and will be a place that people who are potential providers or interested in proposing the service to provide through the sandbox could certainly register with us and stay connected to the progress we're making. And we're especially interested in what sort of ideas those folks may have. We've already received reach outs from several different legal tech sort of concerns, and that will probably evolve into a application or proposal sort of a mechanism for people to ultimately present something that the regulator could assess and decide whether or not to permit.
Yeah, I don't think we're going to have any lack of applications. I mean, right now, we're kind of gathering them, but telling people they just have to wait for a little bit until we get this up and running. But again, with people like Jillian Hadfield and Becky Sandifer and others involved, they have a fair following, and I think our problem will be too many, not too few.
Yeah, I agree with you. I don't think you're going to have that problem. But on the other hand, is there risk to these companies? I mean, you can run this sandbox for a couple of years and then decide it didn't work, and the data doesn't show that it's proper. So what happens to the companies?
Well, there's risk in that sense. You're absolutely right. Yeah. If you bring something and it turns out to be harmful, you're not going to get licensed. You're going to get the plug pulled on you. And that is part of the risk, but that's, your alternative is not being able to play in the sandbox at all, or in the arena. Right. But if you do participate even early on, and you are granted the ability to practice law or to, through these offerings, then you're fine. I don't think that none of us see this as something that we take away from them afterwards. That would not allow for the phase one regulator to work very well.
So I would add to that. I think there's a lot of potential upside for these companies to be involved when these opportunities are first being presented. Because if something proves out in the Utah regulatory sandbox and is demonstrated by data to be valuable and useful and safe for customers and consumers, well, then the open question becomes, why can't that be allowed elsewhere? And wouldn't you want to be the provider that had demonstrated that?
There's a first mover advantage, clearly.
Right. Yeah. I guess what I was asking, I mean, is it possible that after 2 years of running this, you might say, boy, this was a really bad idea. We're no longer going to have a regulatory structure for entities, or we're just going to go back to the old way of doing things?
Maybe. I don't actually see that as a legitimate possibility. But even if that happened, I mean, those who had been admitted in are in, right? Those who are authorized to practice law under certain restrictions, those entities are in.
So there
There's
would be
no sense that,
grandfathering essentially of some kind, even if
yeah,
that were to change. Yeah.
but again, I think I mean, I don't honestly see that scenario as a legitimate risk. I think what we're really going to talk about is what the next level of regulator should look like, the regulator for the 21st century, right? In this day and age of disruption and technology and innovation.
So this is a first step, a big first step in a direction that that you don't think you're going to turn back from.
Right. So, and what I like to tell people is when I first started practicing law, I put a computer on my desk in 1989 and was immediately told, get rid of it, that lawyers don't use computers. That's embarrassing. And I mean, as well as I do, I mean, within 2 or 3 years, they were ubiquitous. I think that that's what we're going to see here. I think it's what we're already seeing with some of the other technology-driven initiatives like ODR, right? It starts with one or two states, countries, and then all of a sudden it takes fire.
Yeah. You did, though, raise some concerns about that catching up. There was an op-ed that the two of you, along with Jillian Hadfield, published in the Salt Lake Tribune a few weeks ago, in which you alluded to reform efforts also underway in California and Arizona, and you said in your op-ed that you were hopeful about those and hopeful that they would bear fruit, but you said, but quote, there's reason to be worried. So what's the reason to be worried there?
Well, we've seen some reform efforts in the past fail. I'm just overjoyed with the Arizona report, and I don't know if you've had a chance to look at it. I think it was just a tremendous piece of work and really insightful as to, for example, how 5.4 came into existence. Other jurisdictions are going to face maybe bigger pushback, but eventually, my point is, this is going to happen. Right?
Yeah.
You can get on early, you can get on late, but figuring out how to regulate based upon data versus some guesses is that model is going to die, and a better model is going to take its place.
And do you think, do you see that Utah, or are you hopeful that Utah becomes a model for what happens in other states?
I'd love to see the day in which there are any number of states that are willing to do this and maybe join together in forming a regulator that they can all look to. I mean, they would still have their own independent authority, of course, but some kind of cross-state boundary regulator that everybody could use to advise them on this subject.
Yeah. Something that the report makes, I think, very clear is that this is ultimately about better serving those who need legal services, and you're going to be closely monitoring this regulatory sandbox. You're going to be capturing data about the regulatory sandbox experiment as it goes forward. How do you ensure that consumers are protected by these experimental programs that you put forward over the next couple of years, or not that you put forward, but that participate in the sandbox over the next couple of years? What protections are in place to ensure that consumers are not harmed by what's kind of an experiment?
Well, that's a great question, and one that we are well aware of. I think the fundamental concept there is that if the regulator is permitting someone to move forward with a particular service that they're offering to consumers, there'll be a set of conditions on that regulator, and probably high on that list would be that they would carry the necessary insurance, to protect against any untoward results from the service that they're providing. And I think, kind of a related issue would be the regulator looking at whether the same kinds of concerns we have when a lawyer provides legal services directly under the traditional model are being adequately protected. Confidentiality, competency, all of those basic criteria are going to be at the center of it. Our regulatory objectives for the regulatory body that we're trying to build are all focused on potential harm to the consumer and potential value to the consumer. So it's, I think, very much going to be a focus of any consideration of a service. What will the benefit and potential harm be to the consumer of this particular service?
Yeah, Justice Holmes, do you have any thoughts on that, on how to ensure that the consumers are protected through this process?
Well, I mean, do no harm is one of the first precepts of the sandbox, right? So ensuring, as John pointed out, that there's adequate security in place, carefully monitoring it as it's going on, pulling the plug early if need be, if we see it. So we're sensitive to it. We have to be sensitive to it. But we also want to make sure that in case something does go wrong, that there's something in place from which those consumers can be made whole.
And this report is titled and focused on equal access to justice. It draws a picture of not just in Utah, but around the world of a justice gap that excludes many people from access to legal services. But it does seem to me that if these reforms go forward, they're going to have an impact on the delivery of legal services across the board, not just for those who can't presently afford them, but even for those who have no problem affording them right now. And I wondered if either of you have thought about that. Have you thought about the implications for how this might change law practice or the delivery of legal services for the better across the board?
Well, absolutely. And this is a sort of I'll call it a silly example, but I think the dynamic is important to understand. There was a time, Bob, when we were all fine with a 79-cent cup of coffee from 7-Eleven. And somehow somebody came along and promoted the idea that we would all get benefit out of a nicer drink and a better cup of coffee. And they even got to the point where they kind of charge a lot for it. And now people have this sense that they probably couldn't do without that stop at Starbucks on the way to work. And I know that's a trivial example, but a little bit that's about making people aware of that opportunity. And I really do see a day when, a small business would kind of consider it the norm to enlist a multidisciplinary subscription-based service to support all of their legal needs around taxes and employment and proper corporate filings and licensures, all in one package that's a mix of lawyers and accountants and tax people and maybe AI people and technology people that have built that in a way that they can deliver it to people at an appropriate price point. Now, is that going to help? I think that helps people out there somewhere. They end up not having to waste their time trying to figure out why their license didn't get renewed on time or whatever it is. So I think that's absolutely part of the package here, and that's to my point about opportunities for lawyers. This is where there is room for the market to grow.
The court has ordered this to go forward. As you say, you're now co-chairing the committee that begins to implement this. What will we see next? What are the next steps in bringing this to fruition? Justice Simonis, do you want to address that?
Sure. So first is we stand up the website. Second is kind of develop the more specific guidelines for how we're going to stand up the phase one regulator. secure the necessary expertise, what have you. And then I think we start opening for business. Maybe I wouldn't say a grand opening, but a soft opening. Start accepting applicants, making sure we tested our own systems. Going from there, I anticipate that within, I don't know, probably not by the end of this year, but within the first 6 months of next year, we're up and running. John, do you think that's too optimistic?
I think that's the time frame, and I think your point about a soft opening is right. This is we're approaching this as a collaborative sort of. We need to hear from the people who may be participating in this sandbox. We need to understand what we're doing in a way that makes it viable for them, at the same time that we're also trying to understand what the right data points are to follow. So I think we're not thinking that we can just write the absolute correct program up, in 3 months and then have it work beautifully from there on. It's very much more of I think, a try it and see approach and adjust where needed.
Yeah, John's making an excellent point. We've decided on a starfish model where we have the kind of the core group that is ultimately acting as the regulator, but we're looking to form kind of subsidiary groups that'll help advise us. So with tech companies, with local businesses, with law firms, with those that represent the indigent, and those that really kind of are living outside the rule of law as it is, trying to bring all that information together in some kind of coherent way is a big part of how we plan on proceeding.
We're just about out of time. I wanted to give each of you an opportunity to kind of give us your closing thoughts on this, or any further thoughts you have that we haven't talked about before we wrap up. So, Justice Simonis, let me start with you.
The beginning and end for me is to improve access to justice in this country. There's a reason we opened the report with the discussion of the justice gap, dedicated a large section to it, and closed with it. We have to do something. We've been throwing billions of dollars at the gap for years, if I can paraphrase my friend Tom Clark, with no real improvement. It's not something I tell people we can volunteer ourselves out of, right? We need to create a new approach. This one's not working, and a huge portion of our population is being underserved. I think we're taking a big step in the right direction.
And John, your final thoughts today.
Sure. Well, I agree completely with what Justice Simonis said, but just to comment on this from the standpoint of lawyers, my practice has spanned over 35 years now. I've been involved in leadership of our profession here in Utah and throughout the country to a degree. I have a son who's a lawyer. I believe lawyers fundamentally got into this practice because they're about wanting to serve clients' needs. And what's really evolved over the last 30 years, if not before, is that we've become increasingly distant from that very population of people. So, lawyers are maligned, right? And people don't understand why they're so expensive, and lawyers get frustrated that they have billable hour requirements. And I'm not suggesting that this approach is some immediate panacea, but I think this has the potential to bring us, much closer to the original idea that people got involved in providing legal services, which is to actually be able to directly advise and benefit somebody who needs their help. And that, to me, is where the access to justice problem or gap sort of meets up with the real instincts that I think lawyers have to find ways to be that helpful advisor.
Well, I think real congratulations are in order for the court system and the bar in Utah for having the courage and the foresight to take the lead on this issue. I know people all over the country and probably all over the world are going to be closely following what you do in Utah. I will include in the notes for this show a link to the report that you issued in August, the Narrowing the Access to Justice Gap by Reimagining Regulation, which is very much worth reading. And thank you very much, Justice Simonis and John Lund, for taking the time to be with us today and tell us more about this experiment that you're embarking on.
Well, thank you for having us. This has been a pleasure.
Indeed, you're most welcome. Thank you.
And a big thanks to Ben Ambrogi for producing and editing this show. That's it for this week. This is Bob Ambrogi.